I had noticed that investor relations pages on websites were being targeted by plaintiffs' lawyers, but I'd never thought about why they were specifically going after those pages. I just thought it was something that they had come up with to do. But I was talking to another attorney, and they speculated that this was because of standing, and I think that's actually that's the reason. So with this situation, we have the main website, and then we have an investor relations website if someone wants to invest in the business. But plaintiffs' lawyers are ignoring the main website when they file their complaints. So you would think, and especially if there are accessibility issues, you would think that the plaintiffs' lawyers would file a claim against the primary website. But no, they will find the investor relations pages, and I'm writing on the whiteboard, and I've got two drawings of squares. One bigger square representing a main website, and then on the footer I have the investor relations IR as a link, and then it's superimposed to a smaller website, which is ir.website.com, and so here we have this investor relations page, and linked to it, I have a drawing of another smaller rectangle that says PDF. So we have these two different websites. One is on a subdomain, one is the main, and the plaintiff's lawyers are going to the subdomain. And the reason they're doing this is because of standing. So whereas the main website might be closed to the plaintiff for a few reasons. I'll get into a few examples in a second. The investor relations page is open and inviting to anybody who would like to invest in the company. And so because it is open to the general public, it is inviting attention, versus the main website may not be. The main website, the plaintiff may not be eligible to participate in the general offering. So let's say it's a credit union, and the credit union only accepts members that are from within a specific geographic region. Well, if the plaintiff doesn't live in that geographic region, then they wouldn't be, they couldn't have been harmed by the website. Maybe it's because it's not practical to visit. So if the main website to visit the physical location, it would be out of state, and it would be 400 miles for the plaintiff to get to, and the plaintiff's never been to that state, then that could be another reason why practically it wouldn't make sense for a plaintiff's law firm to try to establish standing and damages and harm from an offering that really wasn't for the plaintiff. But the plaintiff can make the case that they were genuinely looking to invest in the company, and they visited the investor relations website or the subdomain, and by going to this investor relations website, they found out it was inaccessible and they could no longer access the information. And so the reason I have the PDF here onto the side is because the PDFs are a part of this accessibility. So if you have a PDF and it is not accessible, then it is possible that there could be a claim made that, amongst other issues on the investor relations site, the PDF was inaccessible. And so PDFs are different. They're not the same. Remediating a PDF to be accessible is not the same as remediating a website to be accessible. Two different things. And I would say that PDFs can be, depending on their complexity, more difficult to remediate than a website, especially if the PDF is dozens of pages in length. But the good news is, on the investor relations website or the page, these usually are very simple pages, and they're easy to remediate, and they don't take a lot of time to do so. So that is good. And then what another strategy could be is to make the PDFs available upon request, and then anybody can then let you know whether they need an alternative format or an accessible format. And but this is what's going on with investor relations pages.